suite de la décision du gouvernement du Canada d'invoquer la loi sur les mesures d'urgence en réponse aux manifestations tenues à Ottawa et ailleurs au Canada en janvier et en février 2022. La Commission a été chargée, d'une part, d'examiner les circonstances qui ont mené à la déclaration de l'état d'urgence ainsi que les blocages, y compris leur incidence économique. Les interventions de la police et d'autres intervenants avant et après la déclaration. Cette tâche s'est révélée monumentale, particulièrement à la lumière du fait que le rapport devait être terminé dans un délai de moins de 300 jours. Grâce au travail acharné et au dévouement de beaucoup de trop de gens, pour les nommer, c'est avec fierté que je peux vous dire que nous avons mené à bien cette tâche importante qui nous a été confiée par le Parlement, sans compter que nous avons produit un rapport approfondi et complet, tout en respectant le délai établi par la loi. Thanks to the hard work and dedication of too many people to name, I'm proud to say that we have carried out the important task assigned to us by Parliament, produced a thorough and comprehensive report, and met the deadline set by statute. On previous occasions, I've said that this Commission's task is first and foremost to be a tool of accountability and to foster public confidence. The invocation of the Emergencies Act was a significant event. Members of the public have a right to know what the government did and why they did it. The Commission has already contributed to the public's right to know through its public hearings. For over 30 days in October, November, and December 2022, the Commission heard from 76 witnesses and 50 experts. Many senior government officials were examined, both by Commission counsel and by counsel for the 22 parties to whom the Commission granted standing to participate in the hearings. The witnesses who testified included organizers of the convoy, citizens affected by the protests, police, public servants, and elected officials at the municipal and federal levels. Even the Prime Minister testified, providing his own account of the events in question. There was also unprecedented access to documents produced by dozens of different entities, including the federal government. Commission counsel were security cleared and able to review documents that were otherwise classified or protected by national security or other public interest privilege. For only the fourth time in Canadian history, Cabinet confidence was waived over records containing the inputs that were before Cabinet when it deliberated over the use of the Emergencies Act. Approximately 28,000 documents were disclosed to the parties who participated in the hearings, and approximately 9,000 of those were introduced into evidence. Les audiences ont permis un examen public rare de la prise de décision du gouvernement fédéral, d'autres gouvernements et d'autres organismes gouvernementaux. Des milliers de personnes ont regardé les audiences, lu les transcriptions ainsi qu'examiné les pièces déposées en preuve. Grâce à ces audiences, le public a déjà été exposé à une vaste quantité d'informations. Le public a pu se former ses propres points de vue sur les événements de 2022. Aujourd'hui, avec le dépôt de mon rapport, la Commission contribue à l'obligation de rendre des comptes au public d'une seconde façon, par le détail de mes constatations, conclusions et recommandations concernant les événements en question. Mon rapport compte plus de 2000 pages, réparties en 5 volumes. Il comprend un sommaire, 2 volumes portant sur l'analyse, une description détaillée des activités de la Commission, un rapport résumant plus de 8800 observations reçues dans le cadre de notre processus de consultation publique et l'ensemble des documents d'orientation préparés par des experts pour la Commission. In the report, I chronicle the origins of the Freedom Convoy. I conclude that it was not an organization with clear leadership. Rather, it was a movement comprised of people who shared certain social, economic, and political grievances, but also had countless individual views. Many of the protesters' concerns long predated COVID-19 pandemic. They were rooted in feelings of loss of place within Canadian society, alienation, economic anxieties, and loss of faith in government. That said, the pandemic and responding public health measures were an important motivator that caused the Freedom Convoy to mobilize. Some will want my report to make findings or conclusions about COVID itself, or the correctness of how government responded to it. Those people may be disappointed. My mandate is not about the pandemic or public health policy. Those are important topics, but not ones with which I have been tasked. I do, however, make two observations. First, the COVID-19 pandemic was perhaps a once-in-a-generation crisis. Governments, federal, provincial, municipal, responded in good faith to circumstances as they understood them. Second, however one views those responses, they imposed real hardships on thousands of Canadians. Les gens ont non seulement perdu des membres de leur famille et des amis à la maladie, mais certains ont aussi perdu leur emploi, leur entreprise, leur demeure et leurs économies. De nombreuses autres personnes, comme les travailleurs de la santé, ont travaillé dans des circonstances extrêmement difficiles. Les camionneurs étaient un autre groupe ayant ressenti un poids énorme en raison de la pandémie qui parfois a été encore plus difficile à vivre en raison des mesures de santé mises en place par les gouvernements. L'annonce des nouvelles règles limitant la capacité des camionneurs non vaccinés de traverser la frontière canado-américaine a servi de point de ralliement pour les personnes qui n'étaient pas d'accord avec la politique gouvernementale. Ces personnes ont organisé et mobilisé le mouvement qui est maintenant connu comme le convoi de la liberté. One of the most cherished rights enjoyed by Canadians is the right to engage in political protest. The ability of individuals and groups to publicly voice their dissent enriches and empowers our democracy. It's hardly surprising that government health measures would cause some form of protest in response, given their impact on people's lives. What was surprising was the size and scale of these protests and the way in which they proliferated across the country. The majority of those who participated in the protests were animated by a genuine desire to engage in peaceful demonstrations so that their voices would be heard by leaders in government. They wished to exercise their fundamental right to express their political views, and they had a right to do so. However, like any large group, there were a diversity of views and intentions among the participants of the Freedom Convoy. Amongst the many who intended to protest peacefully were others who had more sinister goals or who were willing to engage in dangerous conduct to achieve their desired ends. For reasons that I discuss in my report, what began as a massive protest evolved into something entirely unprecedented, an occupation of the core of the nation's capital. En janvier et en février 2022, des événements se sont également produits ailleurs qu'à Ottawa. Comme je le décris dans mon rapport, des manifestations ont eu lieu partout au pays, comme à Coutts, en Alberta, à Emerson, au Manitoba, et à Windsor, ici en Ontario. Ces manifestations ont pris diverses formes. Elles allaient de marches pacifiques à des blocages d'infrastructures essentielles. Leur ampleur et leur portée étaient sans précédent. Et la police et les gouvernements avaient du mal à les gérer. En fin de compte, le gouvernement fédéral a déclaré l'état d'urgence. One of the most difficult questions that I have faced is what role I should play in assessing Cabinet's decision to invoke the Emergencies Act. There's no precedent that helps to answer that question. Some parties have argued that I should not opine on the appropriateness of the decision and whether government met the statutory requirement to declare the public emergency order was not within my mandate. They note quite properly that determining the legality of the government's actions is the role of the courts of law. Others, however, have argued that pronouncing on the decision is the raison d'être, the very reason for this commission. In my view, the role and focus of a commission of inquiry into the use of the Emergencies Act will depend, to a certain extent, on the context in which the Act is invoked. In some instances, it may be beyond doubt that the conditions for invoking the Act were met. But there may be other questions that require careful review. In the present situation, however, I'm faced with a statute that has never been used or judicially interpreted. Serious questions have been raised as to whether the legal threshold to use the Act have been met. My assessment of the circumstances surrounding the invocation of the Act, therefore, inevitably involved a consideration of the Act's requirements. While nothing in my report is in any sense binding on the courts that may hear legal challenges to the use of the Act, I have decided to set out my own views on the invocation of the Act and the measures taken under it. After careful reflection, I have concluded that the very high threshold required for the invocation of the Act was met. In particular, for reasons that I discuss in detail in the report, I have concluded that when the decision was made to invoke the Act on February 14th, 2022, Cabinet had reasonable grounds to believe that there existed a national emergency arising from threats to the security of Canada that necessitated the taking of special temporary measures. I do not come to this conclusion easily, as I do not consider the factual basis for it to be overwhelming. Reasonable and informed people could reach a different conclusion than the one I have arrived at. Après mûre réflexion, je suis arrivé à la conclusion que les critères très stricts à respecter pour pouvoir invoquer la loi ont été remplis. En particulier, pour des raisons que j'expose en détail dans le rapport, j'ai conclu que lorsque la décision a été prise d'invoquer la loi, le 14 février 2022, le cabinet avait des motifs raisonnables de croire qu'il existait une crise nationale en raison de menaces pour la sécurité du Canada et que cette crise exigeait de prendre temporairement des mesures spéciales. Je ne suis pas parvenu facilement à cette conclusion car à mes yeux, les faits qui la sous-tendent ne sont pas manifestes. Ainsi, des personnes raisonnables et informées pourraient tirer une conclusion différente de la mienne. C'est donc à contre-cœur que je parviens à cette conclusion. L'État devrait normalement être en mesure de réagir aux situations d'urgence sans avoir recours à des pouvoirs exceptionnels. Ce n'est que dans des cas réellement rares, lorsque l'État a des motifs raisonnables de croire qu'il ne peut pas remplir autrement son obligation fondamentale d'assurer la sécurité de la population et des biens, qu'il est pertinent d'avoir recours à des mesures d'urgence. En d'autres termes, la loi sur les mesures d'urgence n'est pas un outil dont on peut se servir lorsqu'il s'avère utile. Il s'agit plutôt d'un outil de dernier recours. The fact that circumstances evolved to the point where Cabinet reasonably considered it necessary to invoke the Act is regrettable, because in my view, the situation that led to its use could likely have been avoided. As I have explained in my report, the response to the Freedom Convoy included a series of policing failures, though I have also identified sound practices employed by some police services in their response to relevant events. Some of the missteps may have been small, but others were significant. Taken together, they contributed to a situation that spun out of control. The failures were not only in policing. Preparing for and responding to situations of threat and urgency in a federal system requires governments at all levels and those who lead them to rise above politics and collaborate for the common good. In January and February 2022, this did not always happen. Had police forces and governments better anticipated and prepared for the extent of political and social discontent exacerbated by COVID-19 pandemic, particularly in the environment of misinformation and disinformation so prevalent today, and had they collaborated more effectively, there could have been a different response to this unprecedented situation. It's likely that such preparation could have avoided the necessity of invoking the Emergencies Act. En plus de tirer des conclusions sur l'invocation de la loi en tant que telle, j'émets des conclusions sur la pertinence et l'efficacité des mesures prises en vertu de la loi. Même si j'ai conclu qu'il était légitime pour le gouvernement fédéral d'invoquer la loi, mes conclusions sont plus mitigées en ce qui concerne les mesures que le gouvernement a choisi de prendre. J'ai déterminé que les mesures prises par le gouvernement fédéral étaient pour la plupart pertinentes et efficaces et qu'elles ont contribué à rétablir l'ordre sans qu'il y ait de perte de vie, de blessures graves ni de dommages matériels importants. Toutefois, j'ai également constaté que ces mesures comportaient des lacunes, notamment que le décret sur les mesures économiques d'urgence ne permettait aucun pouvoir discrétionnaire en lien avec le blocage des avoirs, ni de marche à suivre afin que les personnes visées puissent faire débloquer leur avoir une fois qu'elles avaient mis fin à leurs activités illégales. I determined that the measures taken by the federal government were, for the most part, appropriate and effective and contributed to bringing a return to order without loss of life or serious injury to people or property. I also found, however, that in a number of respects, these measures were deficient. These included important aspects of the Emergency Economic Measures Order, such as the absence of any discretion related to the freezing of accounts or assets, and the failure to provide a clear way for individuals to have their assets unfrozen once they were no longer engaged in illegal conduct. J'ai aussi abordé les aspects du règlement sur les mesures d'urgence qui me préoccupaient, notamment le caractère vague de ces dispositions relatives à l'aménagement des lieux et son impact potentiel sur la liberté de la presse. Mon rapport s'appuie sur les leçons apprises au cours de cette enquête et offre 56 recommandations couvrant 6 grands thèmes: le maintien de l'ordre par la police, la collecte et la coordination du renseignement au palier fédéral, les corridors commerciaux et les infrastructures essentielles, la réforme de la loi sur les mesures d'urgence, les autres questions à approfondir et la responsabilité de rendre compte suite au rapport. Drawing on lessons learned through this inquiry, my report concludes with a set of 56 recommendations. My recommendations relate to 6 broad areas: policing, federal intelligence collection and coordination, critical trade corridors and infrastructure, reforms to the Emergencies Act, other areas for further study, and follow-up and accountability following the release of my report. I hope that these recommendations will go some way to addressing the various issues and deficiencies of a systemic nature that I identify in my report. Before ending these remarks, I would like to make a few comments about the Emergencies Act itself. I have already commented that it is regrettable that the situation across Canada deteriorated to the point where Cabinet reasonably believed that the use of the Act was necessary. We can all hope that such an exceptional confluence of events and circumstances does not occur again. However, even if it does, and if once again the very high threshold for declaring an emergency is met, members of the public should recognize that the Act contains significant safeguards. Although the Emergencies Act is often referred to as a replacement for the War Measures Act, it is in fact a very different statute. The Emergencies Act was designed to respond to a much broader range of emergencies. It was also intentionally designed to provide extensive checks, balances, and limits to guard against abuse. Il existe en effet des restrictions notables quant au type de mesures que le gouvernement peut prendre en cas de crise. Il est possible de contester devant les tribunaux le recours à la loi et les mesures adoptées en vertu de celle-ci, qui doivent être conformes à la Charte canadienne des droits et libertés. Le Parlement dispose de pouvoirs étendus pour examiner et contrôler le recours à la loi par l'exécutif. Ainsi, bien que le cabinet puisse déclarer unilatéralement l'état d'urgence, le Parlement peut révoquer cette déclaration à tout moment. Et bien sûr, la création de commissions comme celle-ci est obligatoire. Si les futures commissions sont, comme celle-ci, créées en vertu de la loi sur les enquêtes et si les responsables peuvent consulter les documents et les renseignements nécessaires, elles garantiront que la conduite du gouvernement fera l'objet d'un examen indépendant valable. Il importe de souligner que les mesures de protection que la loi sur les mesures d'urgence prévoit sont largement plus étendues que celles que prévoient les lois sur les mesures d'urgence des provinces et territoires au Canada et même des pays à travers le monde. Bien que je recommande diverses mesures de réforme pour que la loi sur les mesures d'urgence corresponde à la réalité du 21e siècle, pour garantir l'efficacité des futures enquêtes et pour renforcer la reddition de comptes de la part du gouvernement, je demeure d'avis que la loi prévoit déjà de nombreuses mesures dignes de mention à ces égards. De fait, lorsque le Parlement a adopté la loi sur les mesures d'urgence en 1988, il a déployé énormément d'efforts pour que son invocation exige de rendre des comptes de façon rigoureuse et fasse l'objet d'un examen public. J'espère donc que la présente enquête et mon rapport contribuent à l'atteinte de cet objectif. The Parliament that passed the Emergencies Act in 1988 went to great lengths to ensure that its use would be subject to robust accountability and public scrutiny. I hope that this inquiry and my report have contributed to achieving this. Merci beaucoup. Thank you. Enjoy the report.
I've heard from my other colleagues talk specifically about some things that should be in there, and just for the record, I'll reiterate what they've said. One, we need to have not only sales of shares, but also sales of assets. For those of you who are out there, you can buy the actual corporation, which is buying the vessel, but you can also buy everything that's within that bowl or within that vessel. And so there's many different ways that smart lawyers and accountants can avoid that. And this legislation isn't smart enough, at least not yet, to catch those. We need to have automatic triggers, regardless of the amount of sales in certain sectors, with respect to certain state-owned enterprise. So, while Conservatives acknowledge this step, that this is a step in the right direction, we're very hopeful that we can have a robust conversation in committee and improve this bill, because it certainly needs it. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires. L'honorable député de Joliette.
Merci, Monsieur le Président.
Thank you very much, Mr. Speaker. I'd like to thank my colleague who also sits on the Finance Committee. First of all, about the point of order, I recall a classic Christmas movie in which it says, "Je ne vous jette pas la pierre, Pierre. Pierre, I would not like to cast any stones." So, in any case, I would like to ask my honourable colleague once again what the government should do to make this bill better. Thank you.
Northumberland, Peterborough said.
Thank you very much, and I very much enjoyed working with the fine member from the Bloc Québécois on Finance Committee. And I'm hoping, and in fact, I'm confident we will work with the members of the Bloc to include things like automatic triggers for reviews by cabinets, for reducing some of the ability of actors to avoid this through things like asset sales and otherwise. We need to tighten the potential loopholes that already exist in this legislation to make sure that we can fully protect Canadian companies, Canadian resources, and Canadian ideas.
And comments? Questions et commentaires. The honourable member for Dauphin, Swan River, Neepawa.
Thank you, Mr. Speaker. I'm just looking for a comment from the members. Why should we believe the Liberals will even use these new powers after 8 years of this inactivity to recognize national security risks?
Member for Northumberland, Peterborough South.
Thank you for me, and I'm not sure it's a great thing that I should speak behalf of the government, but what I would say is certainly this government, whether actually on many different fields, including past application of review of perhaps transactions, which simply has not been done in many cases and should have been done, and divestitures should have happened with respect to state-owned enterprise, but even other issues such as passports, or even putting in place Magnitsky sanctions on human rights. This government just can't seem to get out of its own way.
Questions and comments? Question commentaire. The Honourable Parliamentary Secretary to the Government House Leader.
Thank you very much, Mr. Speaker. I listened to my colleague's discussion on Bill C-34. I can't help but think of some of the incredible investments that we've seen just recently in our neighboring area of where our ridings are. In particular, in Hastings, Lennox, and Addington, the incredible work that the Minister of Innovation, Science and Industry did in attracting Umicore, a multi-billion-dollar operation to build electric vehicle batteries right in a neighboring riding to both of us. Would he not agree that, the type of investments that we can see through the modernization of this act will continue to benefit not just our ridings, but Canada as a whole?
She's ready to. Cool. The honourable member for Northumberland, Peterborough South.
Thank you, Mr. Speaker, and it is a joy to be a neighbour of the member from Kingston and the Islands. That probably ends my career with a Conservative Party, but there we go. But what I would say to him in all seriousness,